First of all, I sincerely thanks to the Manipur Legal Service Authority and the Department of Law and the Legislative Affairs, Government Manipur, for organizing this valuable 2 days orientation program of new criminal laws. By inviting Madam Research Fellow from the prestigious Academy, National Judicial Academy, Bhopal, where we judicial officers are trained. In this 5th and 6th session, Madam Shruti will enlighten us in the topic changes, development, and the challenges in terror-related offenses in the new criminal law. Madam, the people of this small country, small state, has been suffering for the last 40 years, since the early part of 1980s, about the terrorist activities. In the first schedule of UAP Act, we have about 6 organizations which are declared unlawful organizations. But there are still so many other organizations which are not declared unlawful. But they are involving in this some kind of terrorist activity. So, and then our state, in our state, this, Madam may know that is Armed Forces Special Power Act has been imposing since 1980. Then still, this AFSA has been imposing in the hill areas. So, Madam's deliberation in today's epic will be very benefited to our participants today. Frankly speaking, I was not present yesterday's program, but I was the program of yesterday's on YouTube. So, on the second session of yesterday's program, there are many questions about this Terrorist Activities Act, terrorist laws. So today, we must take the opportunity from our Madam about the Dept we have in our mind. So I, being a moderator, request all the participants to participate actively by putting questions to the Madam. Whatever you have Dept in your mind about these new criminal laws. I understand that since the new criminal laws are very new to all of us, there are so many gray areas in our mind. We have to be clarified. So, I request Madam for taking your time.
Good morning to you all. May I request that my PPT just be displayed? While they're putting that up, it's a pleasure for me personally to be here in this beautiful state, and I really am grateful to the organizers, the hosters of this event for having me here. I hope to be able to satisfy your interest and your curiosity on the topic. The area that I have picked up that I would like to discuss with you, as Sir has mentioned, is something that you are dealing with in your state more than other several states of our country. That is terrorism, especially since you're a state which is on the border of our country. So, and may I have the pointer as well, please? So I would just take you through the laws that we need to know about terrorism if you're dealing with. All right, thank you. So the laws that you would require to know laws that you would require to know and issues that are probably involved in terrorist offenses. I will be dealing with it with a development of jurisprudence. This is not a new law that has come in today. It is an area that has been developing over time. And I would give you a bit of an insight on the jurisprudence that has developed regarding offenses against national security. Thereafter, then we can open it up for a bit of discussion where I'd like to have some questions from you, where if I can do my best, I would try to address as many as possible. Apologies, we'll just wait a bit while they get the technical issue sorted. While we wait for them to just get this PPT going, just general, can we talk about what you think terrorism is? If we are dealing with this area, I think it's important to first get our foundations right. So anybody who can just give me an idea on what you think terrorism, the word, means? Anybody? Anybody can just give me a thing? You could just raise your hand and then so that I know who's speaking. What do you feel terrorism, the word, means? Anybody can give an input? Can you just raise your hand so that I know? Yes, sir, please. Mm-hmm. Okay. So sir has said one thing which I think where you're coming from is you're seeing the root word terror. So you say terrorism is what strikes terror in people. And it is something that is an act against humanity, striking at the people in general. Very well put, sir. Anybody else has a point? Sir, please. Fear caused in the general public. Right, sir. Wonderful. It comes from the root word terror, and I would say there's an interesting point. It has a Latin origin as well as a Sanskrit origin. Thrasati in Sanskrit has linkages to the modern day word terror. Sir, you wanted to say something. Unlawful acts of violence to the civilians. Okay. Here I would put a point. What distinguishes any act of violence against an act of terror? Like all acts, there might be acts which are against civilians, yes, but are all acts against civilians an act of terror in simple terms? That's a point to question. Oh. Sir, can you raise your hand? I don't know who's. To the right? Yes, sir, please. Mm-hmm. Right. Okay. So you've gone to section 15. I would just point out there were a couple of definitions that I wanted to take your mind to. I will just give you in a nutshell what these definitions point out. Number one, they point out that unlike any other act of violence, terror has a very specific intent. And that intent is largely a political intent. That is, they have a political agenda, a political objective that they want to achieve. And for that, they use violence and other forms to coerce a group of people or even a government to submit to their will. That's what it brings in, a fear in the general public. That is a creation of such an intense fear that without you being a direct target, somebody else might have been targeted in an incident. You not being a target will, under that fear that you could be a victim tomorrow, would submit to their will. And you would do exactly what they want you to do. That is the first thing, that it has a political agenda behind it. Second is the way the act is committed. And that is different from any act of violence. Like, for example, I'm angry today and I act out. I go and pick up a gun and start turning violent. That is, right now I'm angry, I've acted on that anger. Unlike this form of an act, terror has a very premeditated and a very deliberate way of doing things. That is, they have an objective, they have a strategy, and they have used their resources, garnered resources, to achieve a certain objective. And that's where terror and terrorist activities are different from any other act of violence. The pointer is not working.
Down is next. Up is previous.
Oh, this one. Sorry. So these were the two definitions I wanted to point out to you. We can get to the point that we're talking. Number one, a political objective. Number two, the way it is done, premeditated, deliberate, systematic. Unlike any other act of violence, there's a premeditated objective, there's a deliberate planning and a systematic way of organizing yourself or your group to commit an act. And like any other act of violence, it has an unlawful use of force, which is common. But what is different is the way it is committed and the objective behind it. This definition I would like to put before you. My PPT will be provided to you. You can definitely have a copy and read this at your leisure. But what I would like to reference in this definition, which has been taken from Yaqub Memond's judgment, is the last two lines. And what this focuses on is that it's an act, a criminal act using force. But what is important is these acts are not justifiable for any rationale whatsoever, whether it is racial reasons, whether it's ethnic reasons, religious, it could be even political for that matter, or philosophical. Any rationale provided does not justify what is being done. That is what is unique about terrorism. Looking conceptually at it, I will not spend too much time. Let's look at a couple of aspects. I've broken it down into 4 buckets. Number one is the modus, the actus reus. What is covered is, it is obviously an act of violence, so any form of weapon I use, it could be something as simple as a gun, it could be something as complex as a non-biological weapon. It could be a weapon of mass destruction, it could be a nuclear weapon, biological weapons. That could be one form, that is, I am using weapons to commit an act which causes damage and injury. Second, we have seen this very commonly, people being abducted, hijacking of planes, assassination of political leaders. We have seen these incidents in our country. The modern day terrorism has evolved more beyond just general act of violence. They have evolved with the development of science and technology. So now today, with what forms of science development we have, so the nature of the weapon will modify, the nature of committing it will also modify. So you have today tech-based terrorism. So you might have, and this has become a reality in the northern state of India, Jammu Kashmir, where we had a drone attack on the Air Force base at Jammu. What happened in this incident? There is a drone carrying a parcel of bombs, and that drone, controlled by somebody somewhere else, comes across the border, drops that bomb on a strategic location and causes damage. That is a form where technology is used to commit the act. Terrorism has now evolved beyond that. That is where you're not doing an act which is causing violence, but you are doing an act using technology which causes damage to the interest of the country. So I would take an example of a cyber terrorism attack. What would a person doing a cyber terrorism attack do? He would take a computer, launch an attack against something, an e-resource of the country, bring it down or delete the data, prevent you from accessing it, and as a result of that, cause damage to the interests of the country, its normal functioning, target that country, or even leak information, strategic information about that country to somebody else, which puts that country at risk. That would be a form where there is technology being used to commit an act which is damaging to the interests of the country. So modern day terrorism has gone beyond act of picking up a weapon and striking at the country. It has gone towards striking the interests of a country through technology. Economic terrorism is a modern day one which is still in the process of evolving, where again, you damage the interest of the country by devaluing its economy, affecting its currency and bringing the entire economy down, where the interest of the country is lost. We will see a bit of this kind of a facet in the jurisprudence that has developed. I will take you through it in a bit. What is the intent? As I already mentioned, largely political. That is, there is a political agenda. They want to push a certain agenda they have, and for that they will coerce a government, hurt the people, cause unrest in the country, disturb the law and order and public order of the country so as to force the government to act as per their will. And that political objective is what drives terrorist activities. Outcome? If you're doing an act of violence, somebody is going to get hurt, somebody is going to get injured. Yes, so there's going to be death, there's going to be injury. There's going to be destruction. If you're striking at a place, you would strike at the place, you would destroy property as well. So death, injury, and destruction is a natural consequence of an act of violence. But that is common for all acts of violence. What sets terrorism apart from any other act of violence is the prolonged impact it has. That is, today, if a group of 50 people are attacked in my state, in, say, Bhopal, for example, and this is televised, everybody sees it across the country, you come to know about it, you are afraid. Even though you were not a direct victim, it affects you mentally. That is, I am at risk today. If somebody else is a victim, I could also be a victim. And in anticipation of being a victim in tomorrow, may be, may not be, you submit to their will. So that prolonged impact of fear, insecurity that is caused in you, the psychological trauma that it causes in the general public, is what is unique about terrorism. Who are the targets? So if you're targeting India, for example, the general public, as rightly said by one of our participants, that the general public would be a target. It could also be a section of the society, depending on certain rationale. It could be religious, racial. It could be varied reasons for even for the factum of which area you belong to. So depending on that, a section of society could be a target as well. The people who defend or lead our country are also targets. So your defense, your leaders, public authorities, these are targets. But sometimes terrorism is not against a people, it's against a place. Red Fort, for example, Parliament. Why are these places targeted? Because they have value to our country. So when they target a place for its value to the country and to affect the country as a whole, that place becomes a target of a terrorist attack. But what is important, if you want to distinguish terrorism from any other act of violence, the Supreme Court gives us this advice: look at the mens rea. The intent is far more important than the modus. Any act of violence would have violence involved, death, injury, destruction. But what drives that activity, the mens rea, the intent behind it, is what is crucial. So if you want to identify terrorism, look at the intent and what it achieved, the outcome. rather than the modus. So let's talk terrorism law. Today, after BNS coming in, we have a new set of laws. But this law has evolved over time. Let's just look very quickly at the trajectory of this law. 1860, we have the IPC coming in. At that point of time, there was a chapter, chapter 6, offenses against state, had two major offenses, waging war and sedition. The word terrorism is not used in IPC at that time, but today if you understand these offenses, they would be what we would understand to be falling as an offense against national security, a terrorist offense. So it had a couple of offenses, waging war and sedition, which are the law that governed us from 1860 onwards. 1967, we have UAPA coming in, but UAPA at that point of time was not a terror-specific legislation. It was brought in to deal with internal rebellions. So unlawful associations, unlawful activities was what was penalized under UAPA at that point of time. At that point of time, not applied to terrorism. 1985, we have the first special legislation on terrorism coming in, the TADA Act, Terrorist and Disruptive Activities Act, 1985. Brought in for a very specific purpose, that is to deal with the Khalistani movement. Specific purpose and specific shelf life. So accordingly, it lapses in 1995. Now again, there is a vacuum in between where from 1995 till 2002 when POTA comes in, we have the 1860 law, IPC that applies. 2002, we have Prevention of Terrorist Activities Act coming in, which is a legislation which was brought in view of the increase of terrorism in our country, both in India also as well as in foreign countries. The need was felt that you need to bring in a specific legislation to deal with these kind of activities, terrorist acts. So POTA comes in 2002. Now the problem with POTA was there was widespread allegations of misuse, and because of that in 2004 it was repealed before it lapsed. It also had a shelf life of 2 years, and before it lapsed it was repealed in 2004. Now at the point POTA goes out, UAPA gets amended in 2004 to bring in certain offenses which are terror-specific offenses. So we have Terrorist Act coming in, we have a chapter on terrorist and terrorist organizations coming in UAPA. Now 2023 we have BNS coming in, which has now become applicable from last month. So now from July, these are the laws you need to know. One, we have the Bharatiya Nyaya Sanhita 2023. For short, I will be referring to it as BNS. We have Unlawful Activities Prevention Act, UAPA. And for jurisdiction and investigation, we have the National Investigation Agency Act of 2008. Other than that, that is these major offenses that are covered. You have terrorist acts, you have terrorist organizations. These are offenses that are covered. You would also have allied ancillary legislations that would apply for activities like possession of explosive substances, possession of arms. For that, minor offenses, minor things that tag along with the major offense of terrorism, you would have these legislations coming in which would be relevant. Other than that, we have state-level legislations in various states, though not in Manipur, which deal with organized crime. Now, why organized crime here becomes a related legislation, state-level legislation, is because Makoka being the first, Maharashtra Control of Organized Crime Act 1999 was the first legislation on this area, state level. What it had was it covered organized crime and linked it as a crime that is committed to promote insurgency. From that aspect, organized crime legislations become relevant. So in these states, these state-level legislations would apply. Under BNS now, these are the offenses you need to know. So one is Terrorist Act, Section 113. Second is Waging War, Section 147. And an offense called Endangering Unity, Integrity, and Sovereignty of India, that is 152. We will look at each of these offenses one by one, and I would give you a bit of a jurisprudence that has developed with regarding to these offenses, because these are not new offenses that have come in today. They have been in other legislation, so we can look at the jurisprudence of how these offenses have been interpreted. So Terrorist Act, number one. And because, as I mentioned, actus reus and mens rea both are important parts of the offense, and we need to focus on what the mens rea is to identify what's a terrorist act. I have broken down each offense into two buckets, the modus and the intent. So let's look at the actus reus. So what is covered under Terrorist Act? That is, number one, the use of substances which cause damage. So explosive, inflammable, lethal, poisonous, you use these substances. The second one is you cause damage or destruction to a defense property in India or in a foreign country. Third is overawing a public functionary by criminal force, even causing death. Now here, the word public functionary has been defined in the statute, and it says a person who's holding a constitutional post or a post notified in the official gazette. So the public functionary term is limited to these posts itself. The next one, abduction and detention of persons to compel the government or an international or intergovernmental organization, to my mind seems something on the lines of hijacking or abduction. It seems to be that. This last one is an addition that came in the UAPA and has been brought in into BNS now, and that is unique, unlike the earlier legislations where we have an act of attacking or damaging the monetary stability of the country. And that becomes, in a first time in UAPA, that an activity that is what we were talking about is economic terrorism being recognized as an activity which is punishable. So you have the activity of damaging monetary stability of India. Now here the courts have also been very specific in their interpretation. Damaging monetary stability, what is covered under this activity? And they have said, you have to read it with the lines that follow. By production, circulation or smuggling of counterfeit Indian currency. So they've said the act that is covered under this clause is limited to activities of relating to counterfeit Indian currency. So you have counterfeit Indian currency being produced, circulated or smuggled. That would be what is damaging the monetary stability of India. Now here they've gone as far as interpreting not just smuggling or production of counterfeit currency, even activities related to the means of producing this currency would also be covered under this. Intent. So now mens rea becomes the important. Coupled with these activities, couple it with the intent, and that's what would be a terrorist act. So threaten unity, integrity, security, and sovereignty of India. Now here, unity, I would say, seems to be an act where we say unity of the people, unity of the country. And interesting perspective somebody had once given me that we can probably look back to it as union of states. We are a union of states. So the fact that all our states stay together in a union, in our federal structure that we have, that would be something that is a unifying factor. So unity of the people, unity of the country is what would be covered. Integrity. Now integrity has two connotations if you look at it from a dictionary. One, we are conversant with as persons who are working in a public organization. We have statements being made that a person is of high integrity. That is a personal connotation. That is, I have a high ethical value and high integral moral code. That is for an individual person. For the state, integrity has two connotations. And I would, in a nutshell, say territorial integrity. So it would have two aspects, at least. One is secession and the other one is secession. Two things. One would be territories from our border being taken away by neighboring countries, which rightfully is a part of the territory of India, being taken away from us. And we are seeing this in our border states, where territory is being, in parts being taken away. That is one activity. The second is a territory within our country deciding to break free and declare itself as a sovereign nation in its own right. So saying we are no longer part of India. We are an independent country in our own, we are an independent state. That would be two connotations which are territorial integrity. Security, to my mind, means something of fact of being safe. And sovereignty, from the word sovereign, would be the right of India to govern its territory, to make its decisions, to be independent of any other influence whatsoever, to take its own independent decisions and to administer, rightfully administer its own territory and its own people. That would be something that is a sovereignty issue. Threaten economic security, I will take you through this in the next slide. Strike terror in people in India, understood if you're going to do a violent act here, you're going to terrorize the people here. Strike terror in people in a foreign country. Now this was brought in after the experience of Tada Act in State versus Nalini. If you look at the offense in State versus Nalini, the offense terrorist act at that point of time did not have this factum that you might have an activity committed here in our territory in India, which would be targeted at another country or the people of another country. So in that judgment, they had to hold, if you look back to State versus Nalini, which was Rajiv Gandhi's assassination, what actually happened was a person, not a public functionary, he was not in holding a constitutional post at that point of time, was assassinated by an outfit who had an intent to terrorize or to target the government of a neighboring country. This activity, they had to, by the letter of the law, had to hold that this is not a terrorist act in India, because it was not targeting or the people of India. So striking terror in a people in a foreign country, now with UAPA and the offenses that follow in BNS, now you would have today an act where the activity is done here in our territory, but is intended to another country or the people of another country. That would be an activity that is punishable as a terror act in our country. So that is with our experience of State versus Nalini, 1999. Threatening economic security. Now, this entire offense has been taken from UAPA and brought into BNS. But interestingly, when they took in the offense, they left this definition behind in UAPA. So this definition is not available to you in BNS. It tells you what economic security is. So when you're dealing with it under UAPA, this definition would become relevant. Not so much when you have BNS coming in place. This, to my mind, has three aspects. Economic security, number one, would be security of the economy. So economic, monetary, fiscal stability would be an aspect that is economic stability, economy. The second is economic activity stability. So the means of production, livelihood, food security, these would all be economic activity security. And the third most interesting part that they have added, which is an interesting linkage, that is, you have ecological and environment security, which is having economic implications, linking it to terror. Now that is a very interesting linkage, which I have still to see how it has manifested. Hopefully we will have judgments on this. Now here, one question we've already dealt with is, when they have said the act that is covered is damaging monetary stability of India, it is limited to counterfeit Indian currency, production, smuggling or circulation of counterfeit Indian currency. The second question that came before the high courts was, suppose there is a person, he brings in large volumes of gold into our country. Can that activity be something that is a terrorist act? This question came before the high courts. Most of the high courts are on the same page, except one single bench of a high court. Everyone seems to say that by default, you cannot deal with smuggling of gold as a terrorist act, minus the intent. Again, mens rea is important. And why? Simply, they've given us two rationales why they do not think smuggling of gold is directly a terrorist activity. Two reasons. Number one, they have said that this offense that was brought in, this subclause, that is economic security, was brought in by way of a FinSec committee report. And that FinSec committee report, while recommending the change in the law, gave an idealized clause that needed to be added in by amendment. In that idealized clause, they had put in the word gold smuggling. The legislature, when they put in that amendment, took out the word gold smuggling and brought in the amendment. So when they have specifically taken the word out, gold smuggling, the intention of the legislature seems to be that they do not want to cover gold smuggling as an activity that is a terrorist act. The second reason that they have given is, one, if you look at UAPA Act, where this offense comes from, this is jurisprudence developed in UAPA because our BNS is new. They have said one thing. If you look at section 15, which is terrorist act in UAPA, it has a second clause which has not come into BNS. 15 clause 2 says, activities that are covered under the schedule to UAPA, the treaties under the schedule to UAPA, would by default become a terrorist act. So that schedule does not have Customs Act or treaties related to customs covered in it. So the intention of the legislature seems to be very clear that by default, gold smuggling will not be a terrorist activity. But there is a rider which has been placed, that is, look at the intent. If the intent to bring in large volumes of gold is to destabilize the economy and target the country, target the state, then maybe we might have to examine it more closely to see if it's actually a terrorist activity or not. Punishable terrorist act. So we've seen terrorist act, that is 113 clause 1 tells you what a terrorist act is. Clause 2 provides the punishment. What other than terrorist act is punishable is things done before. That is conspiracies, abetment, aiding, facilitating, inciting other people to do terrorist acts is punishable. Training and recruitment of terrorists for commission of terrorist act is punishable. Membership of an organization involved in a terrorist act. Now here just be very clear about it. Unlike unlawful associations, the organization exists, you are a member. The organization was involved in a terrorist act. On the day that terrorist act is committed, this organization is involved in it. You on the date of the act being committed become liable as a member. So even if you did not know, the fact that you were a member of an organization involved in a terrorist act would make you liable under this clause. Here I will draw a distinction when we come to unlawful associations under UAPA. Harboring or concealing a terrorist knowingly is punishable, and holding proceeds of terrorism is punishable. This is where everything has come from. This is not a new offense, this is brought in from UAPA. So if you look at it, sections 15 to 21 of UAPA and now section 113. But for the exception of one section. If you look at UAPA, section 17 seems to be missing from this list. And section 17 covers funding of a terrorist act. So terrorist funding right now is not an offense under BNS. The remaining is there, but funding of terrorist acts is not an offense here under BNS. Let's look at the second offense, waging war. Now waging war, if you look at the terminology in the law, it is extremely simple. It says whoever wages war against India is punishable. But what is waging war? Is it a war? We generally think of war in the lines of country A versus country B striking at each other. But what is waging war in our Indian law is something beyond that. That is, any person or an organization which goes and strikes at the interest of the state, strikes the state, is waging war against the country of India. So it could be a person, it could be an organization as well. So waging war, how it has been interpreted, this is under IPC. Broadly, again, I'm giving you the buckets of mens rea and actus reus. If you want to understand waging war, this is what the Supreme Court says you need to know. So what is the intent behind an activity that would be called an act of waging war? So number one is to strike at the sovereign authority of the state. I am striking at the country, impeding its right to govern its territories, impeding its right to take decisions, coercing the government to act against, on my instruction, would be something that is striking at the sovereign authority of the state, number one. That comes from Navjot Sandhu's judgment. Second is coercing the government of India. Now here, this is a view taken by the Supreme Court in Kasab's case. Very interesting point they have said, coerce the government of India. Now today, in our mind, if we say government of India, we would understand it as something as government. So organizations and persons who are governing our country would be what I would say, common understanding is government of India. Here they have said, ultimately, the question that comes to their minds is, ultimately, who is the repository of the sovereign power of the state? Any views? Who do you think is the sovereign repository of the sovereign power of the state? Think back, social contract. State. Sir, I can't see. Yes, sir. State. The state. Yes. Where does the state get its power from? Think about that. Exactly, preamble. We, the people of India, elected a government as representatives of us, gave away a part of our rights, social contract. We gave away a part of our rights to them, saying you represent us and our interests, you govern us on our behalf. So we are the people who hold sovereign power. We have given it to the government of India. Very rightly put, sir. So when you strike at the people of India, you are coercing the government of India. And I know I understand where this is coming from, because today, our elected representatives will be under a force, under a coercion if there's a terrorist organization which strikes at all of us. Now, because they are representing us, they need to look out for our interests. They will be under a pressure. They would be coerced to act on the instruction of the terrorist organization that is involved in striking at us. So in that sense, you have coerced the government of India. So it makes sense from that way, but it is a wide interpretation. Disturbing public peace, law and order. So targeting the country, causing massive unrest, communal tensions, law and order problems, public order, disrupting all that would be something that is an act of waging war. Causing communal tensions. So you would strike in a way, strategic way, that is to break up the unified people into two parts, put them into tension that they are striking at each other, they go against each other. That would be an activity that is triggering in one sense, an unrest in the country. That would be something that is waging war. But now today you might see many acts of terror are driven, these are up till now, I hate country India, so I am targeting country India. That is a feeling I have against you, for example. The last one is not so much an external hatred towards somebody, but more of a belief system. That is, I am taught, indoctrinated, or maybe even brainwashed into thinking that I need to do something because my religion requires me to do it. I have to do it not because I have a feeling against country A. I have to do it, even if I don't have a feeling, I have to do it because my God commands me to do it. So when I do that, I'm doing what is, I would call as a holy war. I'm engaging in a holy war, that is, I'm fulfilling the instructions given to me and the command that I seem to have from my God to do a certain act against a certain community or a certain country. So in that sense, I'm acting on a fanatic belief, and that is driven by my religious belief. So many attacks nowadays, if you have seen, are driven by this religious fanatic belief. And that is an intent that is internal to a person or a group, rather than a manifestation of the hatred of a certain country. That is a unique development. Now, if you want to see waging war, you would look at how it is committed, the conspiracy behind it, the mobilization of resources, how they operate it. So it goes back to the words we saw in that definition: premeditated, systematic, deliberate. So I have involved in a conspiracy, planned it with a very specific intent, executed it in a very systematic way. So my modus of committing it becomes relevant. But here, the Supreme Court gives us a word of advice that it is not so important how the activity was committed, rather it's important what the intent was. And I'll give you an example of that. So what is minor elements is the number of persons and the force employed. Why? I'll give you an example of, say, we have tech-based terrorism today. There is a person, he's sitting somewhere with a laptop. How much did the laptop cost? 50,000? Fair enough. He's got a laptop, an internet connection, which is nowadays very cheap. He launches an attack against the defense infrastructure of the country, brings down the entire defense infrastructure. What happens? The country is at risk. There is no defense. Your defense secrets may have been leaked out to other people to use against you. But the point is, how much resources did he use? How many people? One. How many resources? Minimal, 50,000 plus an internet connection. Damage, 100%. So today, it is not so much the number of people, the resources, the force employed. It's more, what was the intent? Did he intend to strike at the state? Yes. He wanted to bring down the state and make it prone to risk, to attacks? Yes. So he has put us at risk. He's targeted our country? Yes. So in that sense, the intent is more important. The lesser, though not irrelevant, I would say, the lesser minor element would be the number of persons and the force employed. So these are a couple of interpretations that the Supreme Court has given. I will give you 4 instances. Number one, we were talking about places being a target. So here we have 2 cases which talk about places being a target, not the people. So Red Fort, number one is Red Fort attack. Second is Parliament attack. Why Red Fort, why Parliament? Red Fort, it has patriotic symbolism for us. We recently had, every year we have this celebration of our Independence Day and Republic Day at the Red Fort. It is a monument, historical monument, and it has patriotic value to our country. So when you're targeting a place like that, similarly, Parliament, why Parliament? It's a representation of our governance. And it's an important monument also for that matter. When you target these places, you're targeting the country to send a message. So when you target these places, it's also an act of waging war. Second, we've already discussed this, religious fanaticism being the driving force. So committing acts based on your religious belief, which is instructed to you, would be an act of waging war. Third is Kasab's case. Now, Kasab's case, we already discussed one thing, that was coerce the government of India. 2 other things come in on the nature of how this attack was carried on. So number one, let's see how this attack transpired. There were a bunch of people, came by boat, landed on the shores of Bombay. And as they hit the street, they started indiscriminately firing at anybody who they saw. Whether they were Indian, whether they were foreigner, they shot and killed whoever they saw. They entered into railway stations, they entered into hotels, they entered into cafes. Whoever they saw on the streets or in these places, they shot and killed. Indians, why? Because you're an Indian citizen. Why foreigners? Because you're on Indian soil. So when you're targeting people either because they belong to India or they are on Indian soil, you are targeting the country as a whole. You're waging war against the country. That is what Kasab's case tells us. Second thing is the choice of the city. Why Bombay? Because we all know it is the commercial capital of India. Whatever happens to Bombay and its economy directly impacts the economy of the rest of the country. So what happened in the Bombay attack, 26/11? When they attacked, everybody who was there got locked up wherever they were. Institutions stopped functioning. So when you have commercial institutions stop functioning, our stock exchange is there. You have institutions which have commercial importance stop functioning, the economy falls. When the economy falls, the currency falls, the economic activity has come to a standstill, all of us pay the price for it. Our entire economy, we lost millions in that particular attack because our entire economy came to a standstill. So when you target the city, because the act of targeting that city will have implications for the rest of the country, you are waged war against the whole country. So in that sense, the choice of the city is important. And similarly, the choice of city, if it was like Delhi, for example, because it's our governance capital, political capital. You target a city because of its implications for the rest of the country. Yes, it's an attack of waging war. This one, more particularly, I would say something on the lines of internal, but this would be a very fact-based determination that each person, judge, would have to make. And this is a question of when we are till now thinking of terrorists as somebody coming from another country and targeting. We might have organizations within our territory, whether those organizations can be committing terrorist act. They are causing internal disturbance. So they have said you need to look at the dominant intention. Now this dominant intention on a fact-based situation would have to be determined in every particular case. They said if the dominant intention is to cause any of these activities, that is overall the government, 1, strike terror in the people of, or a section of people there, 2, third one is alienate a section of people, 4th is adversely affect the harmony amongst different sections of society. If this is the dominant intent behind an internal disturbance, then it would be an act of waging war. So this would be a very probable, I think, issue that has to be determined on a fact-to-fact scenario, whether it's an act of waging war. But this would be the dominant intent to determine if it's an act of war, waging war, or it's an internal rebellion. Third offense, endangering unity, integrity, and sovereignty of India. Now this replaces 124A sedition. And let's look at the nature of the offense that is there before we discuss why it has come in. Again, modus, actus reus. First is what activities are covered. So I speak something, I write something, words spoken or written. Second, signs, visible representation. So I might depict something on a poster, I might make a visible representation, I might make signs of that. Those would be activities covered. What is new, unlike the sedition law, are the next two. Electronic communication. So I might communicate something through the means of an electronic mode. That would be what is now covered under this section. So for example, I write something, a blog, I might post a video, I might post an audio. So all these activities, using electronic communication as the means to communicate something, and it might be anything that I communicate on online through all these means. So a blog, a social media post, photographs, videos, audio, me saying something, or reporting something, all these things which are through electronic communication is what is covered now. Use of financial means would be in the sense I use finance, provide funds to somebody or support an activity through financial means. That would be what is covered. Other means is blanket. What doesn't fall under the first set of it would fall under other means. Now here the intent they have specified, and this is very specific, and here what is important is this is bringing in sedition law in light with Kedarnath Singh, 1962 Supreme Court. In that they had read down sedition law. Earlier, if you look at sedition law, I will show you in a bit, and then I'll tell you why it has come. This is reading it down, and we'll discuss how it has been read down in a bit. So what is covered is doing any of those activities to excite or commit secession, armed rebellion, subversive activities, separatist activities, or an activity which endangers sovereignty, unity, and integrity of India. My advice is the third one, read it in line with the first two. Ejusdem generis, what is the first two? In that line, read the third one. to understand that it has an active tendency of causing an unrest. That would be covered under this offense. What is excluded is legitimate dissent. For example, I today write a blog, and I am commenting on a policy that my government has taken. I disagree with the government, and I have strong reasons for that. I disagree with the government saying, I think this policy is not in the interest of the people of India. Here are my reasons why. I am disagreeing with my government, expressing my freedom of speech and expression to express what my views are on this policy. But I am only doing it with the intent of convincing my government, not coercing, convincing my government to change that policy. Till the point I'm doing that activity minus a violent intent, it is a legitimate exercise of my right under Article 19, Clause 1 to speak my mind, freedom of speech and expression, till the point I do not affect public order, which is a restriction under Article 19, Clause 2. Till the point I do not affect public order, I am well within my right to exercise my freedom of speech and expression. Until that point, if I am dissenting with my government, I am not liable to be punished under this offense. So this is sedition, and that's the new offense. If you notice, the means, two things are new, which we already discussed. That is financial means, and electronic communications is a new addition. Intent, now earlier if you see, sedition law said, whoever brings into hatred, contempt, excites disaffection, that is disloyalty against the government. And in Kedarnath Singh, this was read down that it is not just any act which generally brings a feeling of hatred. It has to be an act, a word, or something that is written or communicated that has a tendency to cause unrest, rebellious activities and all. So only when the thing spoken or written has a tendency to cause public order problems is what would be punishable. So Kedarnath Singh here becomes relevant because now the new offense is brought in line with the interpretation of the Supreme Court in Kedarnath Singh. That is, activities which promote unrest, separation, rebellion would be punishable. Exclusions, legitimate dissent is the same. Punishment has slightly gone up. What was 3 years is now 7. So this is a broad chart of where everything has come from. These are not new offenses. Terrorist Act has come from UAPA minus funding of Terrorist Act. Second, waging war was there in IPC, and we've seen the jurisprudence that has evolved. Endangering sovereignty replaces sedition, brings it down in line with Kedarnath Singh. This is the broad picture that you need to know. Now let's look at how these offenses are chaptered, and this is, brings me to the point of the issues that are involved in these offenses. Waging war and endangering unity, integrity, and sovereignty are chaptered in Chapter 7, offenses against the state, right? Now, Terrorist Act 113 is in Chapter 6, offenses against human body, and this is a departure from the existing law up till July, till 2023. This is the first time we've had a terrorist act, which palpably, to my mind, is an act targeting a state. The intent is against the state, is classed under a chapter which is offenses against human body. Up till now, these offenses were under offenses against state. Nature, broadly, this is a departure from the existing law. Now, how does this complicate things? Let's have a look. Now, the first one, the offenses against state, that is waging war and endangering unity, integrity, and sovereignty of India, are offenses under the state. Question is, who investigates these offenses? From July 16th, I think the position is clear. There is a notification of the government, central government, which says, read all references to the old law, IPC, CRPC, and Evidence Act, as references to the new law, BNS, BNSS, and BSA. So by virtue of that, what actually happens is, the NIA Act can be read down now. NIA has the schedule. Since we're talking about scheduled offenses, it has a schedule at the back which has a reference to the chapter of IPC. So we would now read that chapter of IPC as chapter of BNS. So accordingly, offenses against the state, so two offenses, waging war and endangering unity, integrity, and sovereignty become offenses against the state, become a scheduled offense under NIA Act. So the investigation mechanism would kick in here. We will deal with the investigation mechanism in a bit, so you need to know how this would flow. So now, your investigation would proceed under NIA Act for these two offenses. It's an offense against the state, so obviously sanction is a requirement. So 217 BNSS becomes applicable. You would have to get sanction for prosecuting any person for this offense. Third is because NIA has kicked in, the jurisdiction is clear, it would be the NIA court. So the NIA court would be the jurisdictional court to deal with these two offenses. Now if this is clear, let's look at the next offense, that is terrorist act. Number one, since it's an offense against human body, one is it cannot go, I would not read it directly as a read-in into NIA Act. We would require a specific notification or an amendment to read terrorist act as a scheduled offense under NIA. So it's offense against human body. Right now your jurisdictional court is the sessions court. Okay? So since it is, and the procedure would be as per BNSS. So what would happen, unlike the NIA offenses which are directly taken cognizance of by the special court, here you would have a committal proceedings. So it would be committed to the sessions court for trial. The jurisdictional court would be the sessions court. It's an offense against human body, sanction is not a requirement. So you do not require sanction, right? Now, and this is important for the investigators in the house, you need to know about explanation to 113. What does 113, the explanation, provide? It says, when an offense under a terrorist act is committed, at the point the FIR is registered, an officer not below the rank of superintendent of police has to take a call. He shall decide, not may decide, he shall decide. Decide with reasons or not, it's up to you, but right now it does not specifically mention that you shall decide with reasons, but you should probably have strong reasons for deciding either way. Shall decide, either you register it under 113 or you register it under UAPA offenses. You can't do alternative. You can't have alternative both offenses being, you will decide either or. So you will either register it under 113 or you would register it under UAPA. So that is a call that the police, investigating authorities and the police has to take at the stage of the FIR being lodged. The second question that becomes relevant for the judges in the house is, now see, either they choose 113 or they choose UAPA. Now weigh the pros and cons. 113, BNSS applies. Jurisdictional court is sessions court. Sanction is not a requirement, so your investigation and coming to trial will be faster. But you will not have the provisions under UAPA available to you, that is the extended period of remand, and the stricter provisions of bail will not be available if you go under 113. If you go under UAPA, you would have to wait for sanction. Your jurisdictional court changes. You do get the stricter provisions of remand and bail, yes? So that is the thing. Now the question that comes before the judges in the house would be, suppose they register it under UAPA, not so much a problem, but if they register it under 113 BNS and the matter comes to you after committal, you're framing charges, right? Now you feel you want to bring in UAPA. The first question that comes to consideration is, do you have the power to rope in UAPA at the stage of framing of charge? That is a question I would pose to you to think. And I would just, because of paucity of time, I will just take you to the relevant section that you need to know, and that would be 239 of BNSS. Subclause 1 of 239 of BNSS says that the court can at any point before the judgment is passed add or alter to the charge, and here there is a judgment of Nallappa Reddy which says add a charge means add a new charge under a new statute. That would be relevant. You can look at Nallappa Reddy also for this. You can add a charge anytime before the judgment. Now the question that is, now if you've added a charge under UAPA, you need sanction. What do you do? So then clause 5 of 239 gives you the answer. It says if the added or altered charge requires sanction, you will have to wait for sanction. Sanction has to be taken at any stage. If you're adding, you will have to get the sanction for the new charge. And for that, you will have to wait. Now the third thing that comes up is the moment you add in UAPA and you are the sessions court, you are no longer the jurisdictional court because the NIA court has jurisdiction. So the advice would be you refer it to the competent authority that this is a case where UAPA is involved. He would then take a call to send it to the NIA court. So that would be 3 consequences that you would have to consider. That is an issue that you need to know. So 239 becomes your answer. You can add a charge. You need to get sanction if you add it, and you would have to probably send it to the right court for adjudication. Now, the question that comes is, when you alter these charges, one second. May I have a bottle? The question that comes before us is, both the offenses are exactly the same. Why, you would have to also consider why you need to bring in the new offense. Why do you need to bring in UAPA when 113 already covers the same offense? The punishment is the same, the offense is exactly the same. Why would you have to bring in that offense? You need to also justify if you're adding the charge. So you have something to say? Okay. The point what I'm trying to make is if you have to add the charge, you need to consider why, if at all you require to bring in, if both the offenses are exactly the same, why? Then you would have to look at UAPA for what else it has, which might be relevant considerations when you decide to bring in UAPA. Number one, funding of terrorist act is not an offense under BNS. For dealing with the activity of funding, you might have to rope in UAPA. That would be one reason why you add in UAPA at that stage, at the stage of framing of charge. Second is, there are certain provisions under UAPA which are not available to you under BNSS. And number one is section 44, protection of witnesses. So 44 gives the court very strong powers to take actions to protect their witness. So 44 becomes a relevant consideration. 46 also becomes a relevant consideration, that is admissibility of evidence collected through interception of communication. So that would become a relevant rationale for roping in UAPA when the offenses are exactly the same. So three reasons you would have. One is terrorist funding as an offense needs to be added. And second reason would be you have special provisions under UAPA which become relevant for you as the court to apply. So this is the issue that you have, both for the investigator and both for the judge. There are issues with the explanation which you would have to take up. Let's look. Offenses under UAP I will cover at this point, and I will stop here. I think we need to have a tea break also, then we can come back. Offenses under UAPA, because we're dealing with terrorist law and this is the special legislation, along with BNS, you need to also consider UAPA. So these are the offenses that are relevant for you under UAPA. Terrorist Act we've already seen. It's exactly the same what has been brought under BNS. Other than that, you have unlawful activities and unlawful associations being punished, terrorist and terrorist organizations. Unlawful activities. What are unlawful activities? Let's look at the definition of the term. And again, I break it down into buckets. Modus is similar. Now this looks repetitive because these are acts which are common to most of these national security offenses. So acts, words spoken or written, signs and visible representation and other means, coupled with this intent. So intent to bring about a secession of or secession of a territory, claiming, disclaiming or disrupting or questioning the sovereign or territorial integrity of India, and causing disaffection against India is what is an unlawful activity. So you act or you speak or you write something or you make representations on the point which is targeting either to cause a break away from the country or internal issues of disaffection or anything that challenges the sovereign or territorial integrity of India would be an unlawful activity. So that is unlawful activity. What is the punishable offenses? You either take part or you yourself commit an unlawful activity. You advocate, abet, advise, incite someone else to do it, or you assist somebody else in committing an unlawful activity. This is what is punishable. Unlawful association. We've seen unlawful activity. So whichever association, this is the criteria, whose objective is to commit an unlawful activity, that is acts which are questioning the sovereign authority or territorial integrity of India, etc., or encourages somebody else or assists somebody else, aids somebody else to do an unlawful activity, or its members do this. That is an organization, an association that is meeting the criteria to be declared as an unlawful association. Here I come to the point that I was making regarding membership. We will come to that. First, and an activity that is punishable, that is promoting enmity or imputations that are prejudicial to national integration, that would be now 196 and 197 of BNS. We read it as casus omissus. That is now with the notification of 16 July, we can read this reference as BNS now. So this is the criteria. But now the point is you can't say that, oh, this organization, there's an activity that has happened, somebody has committed an unlawful activity, you aided them, you're punishable as an association. That's not how it works. Here the procedure is reverse. Here the association has to first be declared an unlawful association. And there is a procedure prescribed in section 3 and 4, which provides for the procedure, takes about 3 months. What would happen in this procedure is there would be an association which meets this criteria. The central government, the central government comes at a later stage. This criteria is met, a show cause is given to the association, why you should not be declared as an unlawful association. The matter is referred to a tribunal which is under section 5 of the UAPA, the Unlawful Activities Tribunal. The Unlawful Activities Tribunal then looks into the matter, gives a hearing to the association to defend itself, and thereafter passes an order. And then based on that order, there is an official gazette notification which declares this association as unlawful. The day that, this takes about 3 months, the day that this is published in the official gazette, the offences kick in. So it takes about 3 months, and then after that, these offences. On the date this unlawful association is declared unlawful, if you are a member on that date, you become liable. Second, you deal with the funds of the association now that you operatively know that it's an unlawful association, or you contravene an order regarding a notified place. If you contravene this after it is declared, you are liable. Now here I would draw the distinction between membership of an organization involved in a terrorist act. Here it's reverse. Earlier it was terrorist act committed, the organization was involved in a terrorist activity. On the date the offense is committed, you are liable as a member. Here, on the date the association is declared unlawful, you are liable as a member, not backdated. So here that's the difference. Terrorists and terrorist organizations, with this I would stop for a tea break. Now, under UAPA, there are 2 schedules which list people, individuals and organizations as terrorist and terrorist organization. The criteria for being declared a terrorist or a terrorist organization is this. So you're either involved in an act of terrorism, you're preparing, not committed yet, but preparing for a terrorist activity, or you promote or encourage other people to commit a terrorist activity. That is the criteria. You meet this criteria, the central government by notification can declare you as a terrorist organization in the 1st schedule, or 4th schedule, a terrorist individual. So there are a list, and as Sir had mentioned, I had definitely looked at the schedule. The 1st schedule mentions, I think items 14 to 18 are relevant to Manipur, where there are organizations mentioned which are terrorist organizations declared. And this declaration has a life of 10 years. So now the question is, once this is notified, these offenses kick in. You're notified as a terrorist or a terrorist organization. You're a member, you're punishable. You support, you're punishable. Or you are fundraising for them, you're punishable. So this is what is there. Now here I would just take you to a factual scenario. Let's examine this to get a clarity about it. I am Mr. A. Okay? I go to a certain village in my state, and I have money of my own, legitimate, well-earned money. I take that money, I go to a place, there are poor children. I go and feed these poor children food. I don't talk to them, I don't say anything to them, I don't even interact with them at all. I just fund it, I'm there, and they are fed, they are starving, they are fed, okay? At this event, in the backdrop of that event where the children are being fed, there is a banner. And banner says Organization XYZ. Organization XYZ is listed in the 1st schedule as a terrorist organization. Now the question is, this activity of mine, feeding the poor, is it a punishable offense? What do you think? Sir, please, sir. Section 40, funding. Okay. So you're saying this would be an act of terrorist funding. Okay. How so, sir? Because I'm not giving funds directly to a terrorist organization. I'm feeding the poor. I use it only to buy ration to feed them, and there is no transaction of mine with Organization XYZ. Organization XYZ is nowhere here, not even close to the venue. I do not communicate with them, but I'm only buying ration or funding the I pasted it. Let's be clear, I got it pasted. Absolutely, sir. I agree with you. let's look back on this. Now, and this is an important thing because when we're talking membership, organizations which are banned will not have a manifesto for you to read. Where are you, sir? May I just see? Right, sir, right. He's emphasizing, he's promoting the organization. I would agree with you, sir. The point what I'm trying to make is, you will never find, in most cases, you will not have a manifesto available for you to read that this is terrorist organization with their objective is this, their agenda is this. You will not always find a membership role. You might have sleeper cells. You might never know who's a terrorist as such. So you will never actually know effectively who is a member, who is not a member. So two things come into question here. And then let's look back at the offenses that are there. When I did this activity of feeding the poor, it's a bona fide good act. But why did I bring in organization XYZ's name into the picture? Why? Am I linked to them, as rightfully sir has said? Am I linked to them? Am I associated with them? Am I a member? My activity, my intent seems to be declared by my act of putting their name up. Am I a member? Maybe. My acts speak for themselves. Second is, why did I bring it up? As sir rightly said, am I trying to promote them? Am I trying to highlight them? Am I trying to support their cause? So both ways, either way, it seems to indicate that you have some ulterior purpose behind feeding the poor. So even if it's a bona fide good purpose, the intent behind it may be covert. So we need to be careful to look at what looks at bona fide good acts, whether that is a punishable offense. Now taking this one step further, and here I will stop for a tea break. Question is, now this activity, so far we've agreed it's an offense under either 38 or 39. Funding I would not say, because the linkage seems to be missing. I do not seem to be sending any funds or providing any resources to the organization directly. Now the question is, this activity we've agreed is an offense in some way or the other. Now the question is, suppose this activity and Mr. A are not in India. I am not an Indian citizen, I am somewhere in a foreign country. The question is, this activity is also done in a foreign country. It has nothing, no links to India as a whole, except that the organization is banned in India. I do this activity in a foreign country. I myself am a foreigner. Can we say this act is it's punishable offense in India? Yes. Can we say that you as the court here or the investigator have jurisdiction over this? Is the question you need to think over. Do you have jurisdiction? It's beyond the territory of India. Do you have jurisdiction? Sir, you have something to say. NI Act gives you the power to prosecute beyond the territory. That is, if I'm right, it is 1 subclause 4. And I would read it out for the audience, because now we go to the next issue, that is extraterritoriality. So here, 1 subclause 4, section 1, subclause 2D. It says it extends to the whole of India, and it also applies to persons who commit a scheduled offense beyond India against Indian citizens or affecting the interests of India. So NIA Act gives you investigatory as well as jurisdiction over commission of scheduled offenses or offenses against the interests of India, which are committed beyond Indian territory. So one is that provision. Let's look at extraterritoriality in a bit. And here I will stop for a tea break. Under BNS, you have limited extraterritorial application. So here BNS, if you look at section 1, subclause 5, further subclause C, read with section 75 of IT Act, offenses that are committed targeting a computer resource located in India. Activity done abroad, but the act is targeting a computer resource. So tech-based terrorism. If you're targeting a computer resource in India, then in that case, BNS has extraterritorial application. Second is, this is a new offense that has been brought in BNS, section 48. This is the first time it has come in. And it says if you abet an act done in India, but you are abroad. So abetment of a commission of an offense in India by a person outside India also is punishable, specifically under section 48. So to this limit, you have extraterritorial jurisdiction under BNS. UAPA, now adding to what NIA provides, UAPA becomes relevant. That is, it is applicable to any person who commits an offense beyond India, which is punishable. So there's a UAP offense. Now here, this was unlawful association, terrorist organization banned. It's a offense which is under UAPA. UAP offenses are scheduled offenses. So scheduled offenses, it's a scheduled offense. It's an offense under UAPA. Any person who commits an offense beyond India punishable under UAPA would be punishable as if the act had been committed in India. So in UAPA and NIA, you have extraterritorial application, BNS limited. So in this respect, I just wanted to point out this extraterritoriality, that where can you take a call. So back to this, back to this point, this activity is done in a foreign country by a person who's not in India. Even though it's an activity punishable in India under UAPA, you have extraterritorial jurisdiction over him. That's the simple point I wanted to make. With that, sir, I think we can stop for a tea break if you wish. Okay.
Thank you so much, Madam.